News about federal judges interfering with President Trump's executive actions and orders have been making waves recently. Some people going so far as to say that these judges are holding the president hostage with their rulings. Charlie Kirk mentioned, "We either have a presidency or we have a rule by 677 gavel-wielding dictators. The Supreme Court must put these judges in place. These issues are made worse when you consider that federal judges serve for life. If they are purposefully disrupting a president with their rulings, there's really no end to the disruption outside of impeachment." Which is another trending topic. Tweets like, "Can we have a serious conversation about starting to impeach some of these judges?" are increasing on social media. But before we call for impeachment, it's important to understand the federal court's place in our government, as laid out by the Constitution. So, why do federal judges enjoy lifetime tenure anyways? Should judges be impeached if they are purposefully obstructing a president? Can a federal judge issue an injunction beyond their district, one that applies to all Americans? We're going to look at each of these questions in detail and reference the actual Constitution to answer them. You ready? Okay, let's talk about lifetime tenure and why federal judges have it. Tenure, for those watching who are 30 years old and under, is the ancient business practice of making an employee unfireable as long as they show up to work. They don't even need to try to do a good job, really, because they can't be fired. Just need to clock in and be there. We can define this more academically. Tenure, a status granted after a trial period to a position that gives protection from summary dismissal. Now, tenure has slowly faded from American business practice, and now only certain government positions, university professors, and federal judges get it. Even as early as the 90s, businesses like IBM and General Motors were giving this to their employees. Public school teachers had it, and if you belonged to a strong enough union, you could get it too. Tenure is designed to protect long-standing employees from getting canned for no reason. This is the benefit. The disadvantage is that tenure disincentivizes employees from working hard because they know they can't be fired. And federal judges have lifetime tenure, as long as they maintain good behavior. And I'm only using that term because it's the exact wording found in Article 3, Section 1 of the Constitution. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, and shall, at stated times, receive for their services a compensation which shall not be diminished during their continuance in office. This may come as a surprise to you, but the original Constitution had no term limits on any of the three branches of government: members of the House and the Senate, the Supreme Court, federal judges, and even the President. I've got a video specifically going over the 22nd Amendment, which I will link in the video description if you're curious as to what changed and why. But what were the Founding Fathers thinking not setting term limits for the three branches? Well, in general, they felt that the people would be the final arbiter on whether or not a person would serve indefinitely or not. That's kind of the point of elections. But in terms of the judges themselves, one of the framers' biggest concerns was ensuring fairness in the judicial system. They didn't want judges making decisions based on politics or popular opinion. They wanted them to make decisions solely based on the law, and this is the driving force behind giving them lifetime tenure. Think about elections today. For any political office, all of the endorsements, the donations, the handshake deals behind closed doors. Look, politicians don't have great reputations among the voters because they're willing to bend whichever way the money is flowing. Federal judges and Supreme Court justices are, of course, not elected. They are appointed by the President and confirmed by the Senate. In this regard, they aren't bothered by major endorsements from companies and political interest groups. They're also not concerned about which corporation will be donating to their next election campaign. They can simply focus on interpreting the law and doing their job without worrying about upcoming elections, making donors happy, and changing their interpretations to get more votes. This also means that federal judges, including the Supreme Court justices, can't be removed just because a president or Congress disagrees with them. This brings us right along to the second question we asked earlier. Should judges be impeached if they are purposefully obstructing a president? Well, that depends, really. The only reason for which a federal judge can be impeached are stated in Article 2, Section 4. The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Now, high crimes here is referring to corruption, like taking bribes or abusing their judicial power, serious misconduct, like engaging in criminal acts or unethical behavior, and the inability to perform their duties, such as mental or physical incapacity in rare cases. Now, if a judge was to be found issuing injunctions against the president just to be a thorn in their side, what would you label this? Unethical behavior? Abuse of judicial power? Maybe. But how do you prove that their rulings are purely obstructional when the act in question, the impeachable offense itself, is their interpretation of law? In a congressional investigation, it seems like all a judge really has to say is, look, it may seem like I'm just doing this to obstruct the president, but I am only interpreting the law. It's my interpretation of what the president can and cannot do, and my interpretation may differ from yours. There's a reason that in the entire history of this nation, only 15 federal judges have been impeached, and of those, only 8 were actually removed. 248 years, 8 total judges removed. Impeachment is usually reserved for obvious misconduct, like accepting bribes or getting payments from those who benefited from a judge's rulings. One of the biggest advocates for lifetime judicial appointments and an independent judiciary was Alexander Hamilton. He writes in the Federalist No. 78, "The complete independence of the courts of justice is peculiarly essential in a limited constitution." Hamilton believed that judges needed to be free from outside influences so they could protect people's rights, even if their rulings were unpopular. This is probably a good time to highlight this portion from Article 3, Section 1 again. "Receive for their services a compensation which shall not be diminished during their continuance in office." I bet when I read this the first time, it went right over your head. The reason this is stipulated in the Constitution is so that the president can't put pressure on judges by reducing their salaries if they rule against him. To give a president power to remove a federal judge or take away their salary would break the checks and balances system set up by the Constitution. And you may be asking at this point, if a judge is issuing an injunction just to slow down a president and it can't be proven to be an impeachable offense, then there's nothing that can be done? Well, no. If a federal judge made a ruling just to stop the president from doing something, and that ruling was not based on the actual law or constitution, that means their ruling is probably not going to hold water when it meets the final interpreters of the law, that being the Supreme Court. Yes, this takes time to do for the president and his staff, to petition the Supreme Court to rule on the injunction from a federal judge. But everything will sort itself out when it gets to the Supreme Court. And if it doesn't, that means the federal judge's interpretation was correct, and the president has exceeded his mandate. Look, there's still plenty more on Trump's agenda to get done. I'm sure he has no end to the things he wants to accomplish. If some actions are put on hold to check the legality of what he is doing, he can simply start up something new while the courts sort out other various issues. Is it a pain? Yes. Are judges probably doing this on purpose? Yes. But ultimately, the Supreme Court is going to have to make their ruling, and that will be the final arbitration on who's right and who's wrong. All right. Let's look at the final question now. Can a federal judge issue an injunction beyond their district, one that applies to all Americans? Yes. I know it seems like they're overstepping their bounds, right? Save that for the Supreme Court. But guys, this is the purpose of the lower federal courts. The Supreme Court itself handles around 60 to 80 cases per year on average. That's it. There's just no possible way for 9 justices to examine every single issue happening with the rights of the people in this country, the acts and laws of Congress, and the actions of the president. And while lower federal courts are set up to help individuals within their own districts, it doesn't mean that they are bound to only help those people. They may also review the actions of Congress and the president to assist the Supreme Court. A recent example to jog everyone's memory: a federal judge in Missouri temporarily blocked the Biden administration in 2024 from implementing a plan to forgive student loan debt held by millions of Americans. Now, the federal judge was not ruling on this just for the people of Missouri, but for all Americans, that Biden had no authority to forgive billions of dollars in student loans. And guess what? The Supreme Court agreed when they finally did get a chance to review it. But had this federal judge not had the ability to rule on this, billions of dollars would have been given away illegally before the Supreme Court acted on it. Like, I'm pretty sure the Biden administration knew this probably is not going to fly, so let's get it out quick. I guess my point I'm trying to make is this system isn't perfect, but it works. Sometimes it helps to sort of do a side-by-side comparison, right? What are the benefits? What are the disadvantages? So the benefits of federal judges serving for life and not getting impeached for ruling against a president are: judges have judicial independence. They don't have to worry about losing their jobs if they make controversial decisions. This allows them to focus on interpreting the law fairly. The other benefit is you have consistency in the legal system. Long-serving judges help maintain stability and continuity in legal rulings. The other benefit is protection from political pressure. If judges had to campaign for re-election, they might start making rulings that please voters instead of following the actual law. This is something that we don't want. Okay, now for the disadvantages. The big one here is judges can serve for too long, sometimes into their 80s or 90s, even when their ability to serve is kind of questioned. Another big one is a single president's appointments can shape the courts for decades, even long after that president is gone. And lastly, it can be very hard to remove judges who become ineffective but don't commit impeachable offenses. Do the benefits outweigh the disadvantages? It's really hard to say. Let me know what your thoughts are by writing a comment below. I'd love to hear what you've got to say about our judicial system, the way the Constitution has it set up. Okay, that's it for now. Thanks so much for sticking to the end of my video. I hope you enjoyed it. I hope you learned something. We'll make more videos soon.